Well, I'm just sending this email out to you guys.
He was in here a minute ago.
All the issues, if there's any questions you have, just ask, obviously. Oh, it's like in there like 3 times.
Can we text you?
Oh yeah, no. I'll tell you what I told. I would rather you call me first thing in the morning waking up than not call me.
Look, I've been to that camera so many times. I just saw that ponytail on the news. They all.
It's amazing how many people watch.
But I don't think you need to print them out, frankly. You might want to ask Maria because they're still getting them emailed to their servers. I'd ask Maria.
You know, one of the things
That's the she's doing something.
you're just stupid. It's just stupid. That wouldn't be real. He would have been not taking stuff seriously. He was just with a flag.
Yeah, me too. Growing and growing up. I don't know, maybe this is one of them.
Yes, Mrs.
I don't know if you can play this because it's a
Another one.
Blu-ray,
That's fine.
but you
I
know,
won't
try
try.
it.
Thank you.
You're welcome.
Come on, right?
Yes, thank you.
Okay, Mr. Miller, can you hear me?
I can hear you, Judge. How are you?
I'm doing just great. How about yourself?
Fine, thank you.
All right. All right, good afternoon, everybody. My name is Judge Kathleen McHugh. I will be handling the magistrate hearings this afternoon. I have reviewed each of your probable cause affidavits, and I will determine probable cause and then set bond on each of your respective cases if you qualify. All right, at this point, we're going to call the first case, Larry King.
Present at the main, Judge?
Yes, sir. Yes,
All right,
ma'am.
good afternoon, Mr. King. You're here. Case on a misdemeanor, and bond on that matter has been set at $500. Court date for you. I would imagine you're going to be seeing your judge shortly.
Thank you, Judge. Okay, down the middle, out the door.
So I'm just going. I got the bond.
You got a bond out. Good luck. Judge, Felipe Jaramillo is Mr. Singleton's attorney. He asked if we could reset this matter for tomorrow afternoon.
Tomorrow afternoon?
Yes, please.
Have a seat out.
Okay. At this point, the false ID given to a Leo, it's a $100 bond. So that's the only thing holding him at this point. So if he's able to post bond, that's all that's going to be required
There's
at this
a-
point.
Judge, count
Violation
5
of
is the
probation on a
VOP.
felony. Okay, that's correct. It's also a no bond hold on count 5, which is a violation of probation. And his next court date is June 15th. Does he still want me to reset this for tomorrow afternoon?
This is the attorney's request, so if it's all right, yes,
Okay.
please.
Tomorrow afternoon or tomorrow morning?
Tomorrow afternoon.
Okay, we'll reschedule this for tomorrow afternoon.
Thank you, Judge. Okay.
What am I charged?
False ID, possession, license expired.
Antonio Oliver.
Okay.
Judge is present at the main.
How you doing, Judge?
Good, how are you?
Fine, and you?
All right, you're charged with criminal intent solicitation, conspiracy, third-degree felony. I do find probable cause. The bond has been set in this matter in the amount of $3,500.
Judge, this is a third-degree felony. It's an attempted apparently an attempted burglary of a conveyance.
Right.
I would ask the court to consider reducing the bond to a more appropriate amount. It seems that an attempt should be less than the actual completed act.
All right, does the
And
defendant
I
have
think,
priors?
No priors.
and if you've read the PC, it appears to be a crime of opportunity rather than one of malintent.
Okay.
And I would
Well, at this
ask-
point, I'm being told by the state attorney that he has no prior criminal history. Is that correct, Mr. Linden?
Can we
Yes,
give
Your Honor.
Okay.
pre-trial?
All right, would pretrial take him? I'm going to place him on standard supervision with pretrial.
Thank you, Judge. I'll explain that to him.
Okay? So we
Um,
are
I-
pretrial, standard supervision.
And he can report before noon tomorrow?
Yes, that's fine.
Thank you, Judge. Have a seat. I'll explain to you what's going on. Take that.
Outside, sir.
Jonathan Dinu.
Judge, Michael Weinstein is his attorney. I did speak to his office. He's not going to be here today, apparently.
All right. All right, Mr. Dino, you're here for your first appearance in regards to a possession of alprazolam, possession of oxycodone, possession of hydrocodone, and a caveus on a misdemeanor charge.
Yeah.
Each of your bonds on each of those 4 charges is 1,000, 1,000, 1,000, 250, and we find probable cause as to all 4 counts. And I understand that bond has been posted by
Yeah.
Brad Carlton Bail Bonds.
Yeah.
So you should be released from custody shortly.
All right, thank you.
Okay. I'm
Open
showing
it
you
up,
on
well,
Monday,
I'll-
June 11th at 10 a.m.
What was that?
Court date, June 11th.
Hey, excuse me, Judge.
Diaz.
Judge Kathleen.
That's okay. I'm sorry. Whoever is resisting that violence case is Judge Robinson.
All right.
Judge Miss Q. Oh, call about last
At
name.
10 a.m. on your misdemeanor charge.
Judge McHugh.
Yes, sir.
Far as the capias go, I can't never get a court date for it. I just recently was arrested like a month or 2 ago by the same capias. They told me call this number within 30 days, but when I called the number, they never set me a court date. So that's the reason why I keep catching the same capias.
All right. Well.
So what do I
are
do
you-
about that?
Are you represented by a
That
private
capias
attorney?
been here since 2012.
All right. Are you represented by a private attorney?
Yeah.
All right. What's the name of your private lawyer?
Michael Weinstein.
All right. Well, you have excellent counsel. I'm sure he could help you to resolve that problem.
All right.
Okay?
You have a date. If you bond out, you have to go to court on the 11th. You understand?
All right.
Good luck.
All right.
Fleming,
Cedric Fleming. Sorry?
President of the Maine, Judge.
I was told that he bonded. His bond already posted, so I guess you can keep that date, June 11th. Yeah. Oh, then they take off that court date? Okay. Right, okay, that's fine, you can just leave it. All right, good afternoon.
Hello.
Possession with intent to sell, manufacture, deliver PVP. Possession with intent to sell, manufacture, deliver cocaine. I do find probable cause. Bond has been set for 1,000 on count 1 and 2,500 on count 2.
Thank you, Judge.
Thank you.
Your Honor,
Good luck.
Your Honor, if I may, real quick, just to bring to the court's attention, he is, Mr. Miller, could you have him wait there for just one moment? Could you bring him back, Mr. Fleming?
Mr. Fleming,
Your Honor, he's currently out on bond right now for 2 counts of sale, delivery of cocaine at a near park. I'm bringing it to the court's attention for the court, for Your Honor, to decide if you want to sua sponte or not, revoke his bond. He does have other
Charge.
plans.
What was the date of the first charge?
One moment, Judge. Okay, Your Honor, the pending case He was arrested in April of last year, posted his bond April 7th of last year, or April 4th of last year, 2014.
And for the case I just magistrated on?
Occurred allegedly on June, just yesterday.
Okay, all right. All right, I will grant the request to revoke bond on your charge from last year. From last year, sir, you're going to be held in the custody of the Broward County Jail on a no bond hold.
Thank you.
And you just give me an order to that effect.
Yes, and for the record, case number is 14-4794 CF10A.
Okay. Jorge Manuel Garcia.
Judge, he's at the Paul Ryan facility.
And I didn't know if you wanted to. We have our interpreter here. I don't know if you wanted to maybe get that out of the. Whatever you want.
Paul Ryan, Your Honor.
He needs the interpreter,
No,
correct?
no, that was domestic violence that we reset from this morning. But we can do this first. That's fine.
Okay. All right, Jorge Manuel Garcia. Good afternoon, sir.
How you doing, ma'am?
You're here in regards to two charges, counts 4 and 5. Count 4 is a lewd, lascivious conduct by a person 18 years of age or older upon a person younger than 18 years old. And count 5 is lewd, lascivious exhibition, offender 18 years or older, victim is less than 12.
Now,
A hearing is required as to count 4.
It should be lewd and lascivious molestation, not conduct, correct?
it's
It's the same thing? I mean,
Your Honor, count 4 is a punishable by life felony. So if the court determines that there is proof evident or presumption great, he is not necessarily entitled to a bond. Count 5 is I believe it's a second degree felony. He would be eligible for bond.
Okay. Because right now,
Judge,
there's not no bond on the count 5 charge.
That's a mistake, Your Honor, with this program on the computer with the bond schedule. It should be for hearing on count 5.
Judge,
It's actually should be reversed.
All right, sir, you have a right to remain silent, sir. I'm going to appoint the public defender's office for the purposes of today's hearing.
Judge, my research is that both of these are second-degree felonies,
Well, all right, just one moment. Your Honor.
according to the booking sheet.
Well, one moment, Your Honor.
According to the booking sheet, it does say second degree felony for both.
Yes, I understand, Your Honor, but in that there could have been a mistake with the information on the booking. I'm looking at and I can print this out for the court, assuming this is what I believe to be is true. Yes, Your Honor. If I could print out the information, I'll print out the information for the court.
Could you provide the statute numbers, Mr. Linder?
Excuse me?
Could you provide the statute numbers?
I'm going to. Your Honor, I'm going to
Thank you.
provide the court with a copy of the information. And also, what I'll do is, I don't believe, does Your Honor have a 2015 statute book? I don't think one's up there, but you can use mine.
Okay.
Under the statute number, and it's 800.04 5B. It is a life felony.
Okay. And that is count 4.
Yes, in the information, it's actually count 1.
Okay. All right, I'm reviewing a copy of the information for these two charges. State has charged him, by way of information, with 2 counts, lewd or lascivious molestation, count 1. Count 2, lewd or lascivious exhibition. Statute number, the applicable statute number is Florida Statutes 800.04 5B as to first count. The second count is 800-047A and also 800-047B. All right. So he's not entitled to a bond count 4, correct?
Assuming the court finds proof evident or presumption great.
Okay. I have reviewed the probable cause affidavits, the police narratives, the statements of the listed witnesses in this case, photographic evidence. Does the defense have any arguments in contravention of me finding proof of guilt evident, presumption of guilt great?
Judge, for the record, I'm just going to reserve argument for any future hearings.
At this point, I do find proof of guilt is evident, presumption of guilt is great, and as to count 4, you're going to be held in the custody of the Broward County Jail, no bond. No contact directly or indirectly with the listed victim in this case. As to lewd or lascivious exhibition offender, 18 years of age or older,
And Your Honor,
just count 5.
yeah, Your Honor, we're going to be seeking a $100,000 bond. Just to advise the court why we're seeking this bond. On count 1, he's being held on a $500,000 bond, and that stems from the probable cause I also provided to you with the other allegations. Your Honor, he's also been charged with a lewd and lascivious, not a lewd and lascivious, indecent exposure that he's currently in front of Judge Lerner Wren on, and that's only because in that allegation, the alleged victim did not actually observe what he was doing. He's also being held no bond on pending felonies, and in his past, he has an attempted strong-arm robbery.
That is a bondable offense, correct, State?
Yes, yes.
All right, so I am going to, I do find probable cause as to that charge. I am going to set bond in the amount of $100,000 on count 5, level 2, pretrial. Actually, make that level 1, pretrial, GPS. No contact directly or indirectly with the listed victim in this case.
Judge, for the record, I'm invoking his right to remain silent.
Okay, thank you. Let me write on there proof of guilt evident, presumption great. Here's all the police reports. Maybe a review. All right.
Actually, Your Honor, I was just asking this could be kept with the court office these are witness files.
Okay. Okay, thank you.
Did you want to do Mr. Tran, Judge?
All right, we have a interpreter here, did you say?
Yes, it was a domestic violence case that you reset from this morning.
Tran?
It was Tam Tran.
Oh, that's the Vietnamese.
Yes, Judge.
Good afternoon, Your Honor.
Good afternoon.
Hi.
Okay, Ham Tran. Good afternoon, sir.
Dạ,
Chào
good afternoon.
chào anh.
My
Dạ,
name is
chào
Judge
con tòa.
Kathleen McHugh.
Tôi tên là Catherine McHugh.
I'm going to be conducting your magistrate hearing this afternoon.
Hôm nay tôi đứng đây tôi sẽ lo về cái vụ án của anh.
I will determine whether or not there's probable cause to detain you.
Tôi cũng muốn biết là coi thử trường hợp như thế nào để chúng tôi xử sự cho anh.
And if there is probable cause, I will set a bond in your case.
Và nếu mà trường hợp mà anh có chúng tôi gắn tội cho anh thì anh phải có cái với một cái số tiền để mới ra khỏi tù được.
Okay, I have reviewed the probable cause affidavit and I do find there is probable cause.
Thì dĩ nhiên là tất cả những cái gì mà chúng ta làm thì anh phải chịu cái tiền mà phải bồi thường lại.
All right, does the defendant have any prior criminal history?
Your Honor, he has some DUIs in the past in Arizona.
Dĩ nhiên là anh có trong quá khứ thì anh đã có những cái lúc mà lái xe mà bị say sưa ở tại Arizona.
Dạ đúng.
One was
Đúng rồi.
he said that the system is showing he was sentenced to prison.
Có một lần thì anh đã bị nó bắt và bỏ vô tù ở tại đó.
Dạ.
Does the state have a
10 năm trước
recommendation as far as bond?
Your Honor, I would be asking for a. Your Honor, there was also a threat to kill in this case, and based on this prior, I'd be asking for a $5,000 bond, no victim contact.
Thì ở đây thì theo những cái dự án xảy ra như vậy thì tôi dự định là anh cần phải anh cần phải bỏ ra 5.000 mới cho anh ra khỏi tù tạm thời.
Judge, I've reviewed the probable cause affidavit. It appears that he's alleged to have slapped his wife. Not excusing it or minimizing it, but it's not the worst case of domestic violence we've ever come across. And the victim did not have any marks, bruises, or signs of injury, and was reluctant to cooperate in the prosecution. I'd ask the court to consider pretrial release on this one. And I would ask the court also to explain to Mr. Finn what no victim contact means and the consequences of having contact after being ordered not to.
All right, sir. I'm going to set bond on your case in the amount of $1,000.
Thì bây giờ là quan tòa định là cho anh chỉ trả 1.000 để có thể anh có thể bỏ tiền ra để ra khỏi tù.
You're not to have any direct or indirect contact with the listed victim in this case
Thì
until further order of the court.
anh không có được liên lạc và cũng không có được liên hệ gì giữa với cái người mà anh đã chung chạm với.
You're in the possession of any firearms or ammunition?
Trong
Custody?
Trong một cái lúc nào đó mà anh có súng hay là có những cái gì mà nó có thể gây hãm hại tới người khác.
You are to surrender the firearms and or ammunition to your local police department.
Và anh phải nếu mà trường hợp ta bắt anh người ta sẽ gắn tội cho anh, còn không anh phải có những cái đó anh phải đem lại cho người ta.
You're not permitted to call the listed victim.
Cũng như là không được gọi cho những người mà qua điện thoại, mà không được gọi điện thoại, không được text, không được email cho những người mà anh liên hệ với.
Or have a third party contact her.
Hay là có những những người lo cho họ mà họ muốn giữ trong cái dự án này đó thì không có được liên hệ với họ.
If you violate this no contact order,
Nếu mà trường hợp mà anh làm trái pháp,
I could revoke your bond.
tôi có thể lấy cái tiền mà tôi định ra 1.000 đó.
And you could go back into custody on a no bond hold.
Và anh có trở lại tù và không có thể ra khỏi tù và cũng không có thể mua chuộc được.
You could also face new criminal charges.
Và anh cũng có thể bị phạm tội phạm pháp, và theo luật thì tòa sẽ xử anh nặng hơn.
Do you have any questions?
Anh có câu hỏi gì không?
Dạ, có câu hỏi tại vì em nói về câu chuyện của em, có được không? Nói cho tòa nghe được không?
I would like to know if I could speak up about my job.
All right, where do you work, sir?
Anh làm ở đâu?
Em không nói về cái câu chuyện, cái việc làm của em, mà em nói về câu chuyện lý do tại sao em tát vợ em cái không có gì hết, mà tại sao em phải bị bắt vào tù mà em thấy bị bon, em thấy vô duyên, đó là em không có cái tội gì đó, tại vì người vợ gây ra cho em mà. Người ta đem được.
Your Honor, I just don't, my concern is I don't understand when I have. This is more like I don't know how I get into this problem, and all this bond, and because actually it's just hurts. She's the one that caused the problem, and it's I just don't know how I get I get into this position.
Okay. All right, sir. Well, you need to post the bond. Yeah, you have a $1,000 bond.
Thì tôi cũng biết rằng là cái chuyện này để giải quyết, nhưng mà hiện tại là anh cần phải trả 1.000 anh mới ra khỏi cái tù.
Consult with an attorney.
Và chuyện gì đi nữa anh cần phải nói chuyện với luật sư của anh.
And fight these charges once you're released from custody.
Thì dĩ nhiên là luật sư của anh sẽ bảo vệ anh, và khi đó nó rõ ràng hơn.
Best of luck to you, sir.
Em nói chung em đâu có muốn luật sư.
Tôi xin
em không có muốn luật sư.
Tạm biệt anh.
Nói em không có mướn luật sư đó.
Because I couldn't afford for a lawyer.
All right.
I fight for myself.
Qualify for the services of the public defender if the state files
Nếu mà
charges
trường hợp
against you.
nếu mà trường hợp
their office to represent you.
Nếu mà trường hợp mà anh đủ khả năng coi như là lương bổng mà tiền bạc không đủ thì họ sẽ cho anh một cái luật sư của để giúp anh, là luật sư không có tốn tiền.
Không cần, em nói là em có thể em không cần defend, em cần find myself, cái bản thân của em được rồi, em tự biện hộ cho em được.
I don't need a lawyer. I just think that I can defend myself.
Well, that's never a wise decision, sir. The last person who represented themselves in my courtroom was convicted in about 5 minutes after a jury trial.
Thì dĩ nhiên là anh biết rằng nếu mà không có người luật sư mà đứng ra để bảo vệ anh đó, thì chắc chắn anh sẽ cuối cùng anh sẽ bị thua cuộc, chứ không thể nào anh thắng cuộc đâu.
Okay. All right. Thank you, sir.
Cảm ơn anh nhiều.
I will send someone out to sign you up with an interpreter. Off you go. Good luck.
All right. Charles Dunlap.
$1,000.
Yes. Thank you. Did I sign your form? I think I did.
Yeah, you did.
All right. Thank you. Charles Dunlap.
Thank you.
Good afternoon.
Make sure you were perfect first. I didn't know I was
Okay.
giving
Thank
it.
you. All right. Where's Mr. Dunlap? Charles Dunlap.
Dale? How could he possibly be talking to him?
You bond out?
Dale?
Dale, is Charles Dunlap there?
Not here.
He's not there.
We're on the same page.
Dunlap?
Ben?
Yes.
Okay. What's his number?
All right. It's not answering?
Okay, I'll call him.
Looks like they didn't bring him down.
They didn't bring
I'll
him?
call him.
Well, not too many people left.
Well, how about this? How about we reset it till tomorrow afternoon? Tomorrow afternoon?
I will call him. Thank you. Good luck.
Okay. All right.
If they need him for right now, we'll call him.
They'll go get him if you need him now.
I mean, if the attorney
Can they go get him?
Yeah.
Yes, ma'am.
Are they going to do that right now?
They're going to call for him right now,
All
Judge.
right, let's pass that. All right.
go pick up the goddamn like 12.
Jacob Mathis.
He's present at the main jail, Judge.
All right, good afternoon. You're in a municipal city ordinance violation, trespass after warning. You find probable cause.
Yes, ma'am.
And set the amount of
So they need him
$25.
for right now, Judge ASAP.
We have the city prosecutor present.
I've had a chance to speak with him. If Mr. Mathis would like to resolve it, we were asking for a withhold time served.
Yeah, he was on it this morning. I know.
That was conveyed to me by the city of Broward. I have not personally looked at his background. I assume that it was himself or priors of some sort that they come to
All right, Mr. Atri, yours is a withhold court cost.
We were hoping for that, Your Honor.
Okay, Mr. Mathis, you want to resolve this today?
Yes, ma'am.
All right, you want to raise your right hand? Swear affirm, tell the truth, the whole truth, nothing but the truth.
That's all I can do.
All right, place your hand down. Please state your name for the record.
Jacob Aaron Mathis.
You want to plead no contest to this charge?
I sure will. No contest or guilty, whatever you want to do it.
No.
In exchange for that, I'm going to withhold adjudication and order you to pay court costs. Is that how you want to resolve it?
I can sure try to pay court costs. I mean, I work under the table. I don't really have a full-time job.
All right. All right. So I'm going to sentence you to a withhold adjudication and court costs.
Thank you, Your Honor.
I'll give you 60 days to pay. How's that?
Thank you, Judge.
Thank you. Do I get a printout of that?
No, sir.
Out you go. Good luck.
Outside to your house, to this college. Help me out.
Which one? No, wait.
We were 917. We were 917.
I don't know if it's gonna be all night or all week. I don't know who that is. Let me know about it.
All right. Next case I have is
First paying in July. Get paid first time.
George Storoshenko.
George, approaching.
Okay. Welcome back, Mr. Storoshenko.
Excuse me?
I said welcome back.
Oh, thank you.
Okay. You're here for a municipal city ordinance violation. I do find probable cause, and your bond has been set in the amount of $25. Does the city have an offer to extend it?
I have not been in touch with the city of Plantation. As such, I course to an offer, nobody else
I have nobody to bond me out. That's what I'm saying.
Yeah.
All right. He has counsel on this, correct? Or not?
Mr. McLawrence only represents the city of Fort Lauderdale, and I work with Mr. McLawrence. So, Mr. Shade, maybe, I don't know, Your Honor.
All right, sir. Do you want to resolve this today?
Yes.
All right. I'm going to adjudicate you guilty, sentence you to time served. Is that how you
Okay.
want to resolve it?
Yes.
All right. You want to raise your right hand? Raise your right hand, swear affirm, tell the truth, the whole truth, nothing but the truth.
I do.
Place your hand down. State your name for the record. Please state your name for the record.
Your name. State your name.
Oh, George Storoshenko.
All right. Do you want to plead guilty to this charge?
Yes.
All right.
Well, no
adjudicate you
contest.
guilty, sentence you to time served. You're done.
Thank you, Judge.
All right, thank you.
All right. Valencia Chanel Weldon.
Oh, you should see that came in like a devil.
Hold on, Your Honor.
Valencia Chanel Weldon.
Yes, ma'am.
And then he came in the move
Counts,
5
count one, selling drugs, schedule 1A, B, 1D, 2A, 2B, or 2C4. Same charge on count 2.
Sure, that was the perfection. Should be still, I believe it should still be attached. On the second page, it states that the. On the second page, it says the pills were identified by poison.
I'll say something, sir. Hello?
One moment, ma'am.
You look like
May I just inquire as to ties to the committee? Ma'am, what city do you reside in?
I'm from Deerfield Beach, sir.
How long you been living there?
All my life, sir, and I just got my kids back from my mom, and I just got a job.
Are you working?
Yes, sir.
What do you
and I don't
do?
even have any money. I just moved in my apartment. I work at Boston Market. I know it's not much, but it's something better than nothing.
Do you have anybody to help bond you out?
Excuse me, sir?
Do you have anybody from your family that's going to help bond you out?
No, sir. No. I was trying to get ROR because right now my mom has my kids and my sister's kids. We don't know where my sister is. So.
Okay, Judge, will the court?
I got a job, but it's not much. I get paid $8 an hour.
Will the court consider, due to the nonviolent nature of the offense, pretrial release? She does have a family. She, based on her testimony, she is gainfully employed. She's been living. She does have ties to the community. She does have family down here.
Yes, and Your Honor, I wouldn't oppose the court reducing the bond because I agree at this point in time it looks to be more like possession civil possession and possession with intent. That being said, she was just arrested April 25th for theft, possession of cocaine, and introducing contraband into a detention facility. She bonded out on a $2,000 bond. Now, a filing decision has not yet been made on that. She was then arrested on a, looks like, she was then arrested May 7th when her bonds were surrendered on the possession of cocaine and introduction to contraband. Her other priors include 2012 possession of marijuana, 2010 felony battery, great bodily harm. She violated probation on that case. Theft 03, obstruction 03, aggravated battery and retaliating against a witness or a victim in 02 with the VOP. Possession of cocaine 99 under the name Tasha Harris. 02 grand theft with the VOP. 02 possession of cocaine, MDMA, marijuana.
Sir, since I have my kids,
She bonded out on that?
She's actually bonded out on twice. She posted on the cocaine and introduction, she posted a $2,000 bond originally. Her bondsman surrendered the bond. She got arrested upon the bond surrender, and then she posted again.
Yeah, my boy, the dude.
The case is
who
on
posted
file?
my bond. Excuse me.
Technically, you could. Normally, we don't recommend it in fairness, Your Honor, because it's been over 30 days and a filing decision has been made.
Gotcha. All right. At this point, I do find probable cause, and I'm going to leave the bonds as set for $2,500 each count. So you have a total bond amount in this case of $5,000.
Judge, just to be clear, are you finding probable cause on the sale or possession? Well, I think the state conceded this is a possession, not a sale.
Yeah, but certainly the court is free to say, I think a bond, even a bond increase would be appropriate considering her pending case, her other priors. So.
Of course,
But when my bond got surrendered on one bond, it was not because I called out the charge. I didn't catch the charge. Oh.
Charles Dunlap. Did they find him yet?
Jeff Dunlap.
President the
Here
Mayor.
he comes, Judge.
All right, Mr. Dunlap, you're here this afternoon. With regards to a case on a misdemeanor charge, a municipal ordinance violation. The bond is set at the amount of $500. Does the city have an offer for him to resolve this case?
Yes, Your Honor, it is a adjudication.
Is there a reason for this case?
I imagine based on the charge itself, and I'm not entirely sure what his background is.
Would the court consider a withhold?
All right, well, they can't tell me he's got priors.
I know.
Does anyone know his... Your Honor, 72733? Yes, 7. Okay, Your Honor, 17. It's weird. I don't see a formal arrest in Broward previously, Your Honor.
Okay. All right, sir, if you want to resolve this, I'd give you a withhold and court costs.
Like, right now,
Want to resolve this?
Talking to you, sir.
What's you talking about?
Do you want to resolve it?
Yeah.
Do you want to fight it or do you want to plead it out?
Want to resolve it?
I don't want to fight it.
You don't want to fight it? You don't want to plead it? Which one?
I don't know.
You want to go home, right?
Yeah, I want to go home.
Your attorney is right there.
I want to go home.
If you want to resolve it, sir, no contest is what I would suggest. That means you're not admitting nor denying. You're just not contesting the charge because you feel it's in your best interest.
All right, sir, you want to raise your right hand? Swear from tell the truth, the whole truth, nothing but the truth.
Nothing but the truth.
All right, place your hand down. State your name for the record.
Charles Dunlap. Charles Dunlap.
All right, you plead no contest to this charge. Yes?
Yes.
Yes? Okay. All right, I'm going to withhold adjudication, order you to pay court costs.
Thank you, Your Honor.
All right, thank you.
Good luck. That's it, sir. Go back outside.
Wow.
You're done.
You can get out. You can get out later on.
Later on.
Later on,
Yeah, you go home later on.
Yeah, just go out there.
Oh, okay. All right, that's fine. All right, we have Eva Candeloro.
North Broward, Your Honor.
This is a Hollywood and Fort Lauderdale.
Right. All right. Double win. All right, Miss Candeloro, you're here on 3 matters, as I told you this morning.
Okay.
You're on 2 cases on 2 misdemeanor charges, and also a violation of probation for my probation, which are being held no bond. And the 2 cases on the misdemeanor ordinance violations, one out of Fort Lauderdale, one out of Hollywood. Each of those 2 charges, you have a bond amount of $250 on the first one and $100 on the second one. Does the city have an offer to resolve?
Oh, yes, Your Honor. She does have several in her background. As such, it'd be
Okay. All right, Ms. Candeloro, do you want to resolve these misdemeanor? Well, you know, if she resolves these, it might be used against her on the violation of probation, too. You know, Ms. Ma'am, do you want to resolve these misdemeanor ordinance charges?
Yes, but I'm indigent. I have no money. You declared me that before. That's why I didn't know that I was supposed to go, because they told me that I was declared indigent and told me that they were waived.
Well, I have concerns. I do remember her in my courtroom, and I know there were mental health issues with her. And
Yeah,
I
but
order earlier this morning for a mental health. I don't know that I want to take a plea from her, knowing that there's a mental health screen.
Agreed, Your Honor.
no, I already took it today.
Would you, I would agree with that. At the same time, on the MO cases, would you consider Mr. McLawrence to be appointed for her?
Yes, I will. I will appoint Mr. McLawrence on those. All right, ma'am, I'm going to see you in my division. June 11th, it looks like. No, it could be June 11th. You said
Today's the 9th.
May 9th?
June 9th.
Yes, I will. I'll appoint counsel on both. Can you set this in my division for next Monday? Okay. All right, ma'am, I'm going to see you next Monday in my courtroom at 9 a.m.
All right. Thank you. All right. Have a good day.
Do I need to sign all 3 of these or just one?
Is Michael Brown here? Yeah, he's right over the window.
Michael Brown. Is that main jail?
Main jail.
Michael Brown.
Main jail.
Okay, good afternoon, Mr. Brown.
Good afternoon.
Here for a municipal city ordinance violation. I do find probable cause. Your bond has been set to the amount of 25. Does the city have an offer to resolve this case? Which city is this?
Plantation.
Plantation.
You don't work Plantation?
I do not work, I live in Plantation, but I don't work there.
Okay.
Hey, Your Honor.
Yes, sir.
I would like to let you know tomorrow. I've been waiting on this housing for like 2.5 years. I have an appointment at 10:30 in the morning with HUD Housing. I would like to resolve this today.
All right, sir. I'm not going to take a plea from you today. Does he have? He doesn't have counsel on this. I can't even.
A what?
Counsel if it's a plantation case.
I don't know who. I can text Hollywood's and see if he does plantation as well. I kind of don't think he does.
Yeah, okay.
So I don't know. Our Hollywood, we have our guy.
Right.
Percent.
Right.
But not modified. Because, yeah.
There's no way I can resolve this?
Judge,
Yes, sir.
I know that I don't have any standing here, but the court can dismiss this case for lack of prosecution.
Oh, that's an interesting one.
Your Honor, let me make a few calls and if I can stand in for
Alright.
the city of plantation.
All right, let's put this
I
on
got-
recall.
I gotta
We're gonna
make
try
that
and,
appointment
the
tomorrow.
prosecutor here in court's going to try and contact the city in regards to this ordinance violation. All right, what else do we have?
How's that?
Have a seat, sir.
Yeah, it's all right, man.
Good job.
How about Daniel
Baby's 19 months.
Gerbu?
Daniel?
Good afternoon, ma'am.
Defense motion for Broward.
Yes, Your Honor. Give me one moment. This has been downfiled to a misdemeanor. Give me one moment. Yes, the felony was no info.
All right, sir, the felony charge of aggravated child abuse was declined by the state attorney's office by the filing of a no information. So he's only left with count 2, that's touch strike battery.
Yes, Your Honor.
And what is the bond on that?
The bond was originally set on the battery at $10,000 with a pretrial release GPS monitor.
Okay.
And here.
All right, sir.
Just,
So you have a $10,000 bond with pretrial release and a GPS monitor on count 2, the touch strike battery.
Judge, is this going to be refiled as a misdemeanor, or is it coming to your division?
It's already been filed as a misdemeanor. The state declined the felony, and they've only filed 1 count of a misdemeanor battery.
He has a misdemeanor.
Okay. Can we set him for arraignment before Your Honor as soon as possible?
It's already been scheduled for June 18th.
Set for June 18th for an arraignment.
June 18th, so that's next week. All right, good luck.
I'll find out from Plantation.
Mr. Shade.
Are you bringing
Did not do the city plantations. As a courtesy, you can only have it in the afternoon. Could it be reset for tomorrow, and I'll get a hold of plantation city attorneys.
All right, so Michael Brown, we're going to reschedule this ordinance violation matter from Plantation until tomorrow afternoon.
And that's, I'm trying to be a friend of the court.
Okay.
Thank
you.
I'm gonna
Thank
miss
you.
my
Appreciate
appointment
it.
in the morning. Yes, you are, sir.
Judge, did you hear Mr. Brown explaining to you his issue with HUD housing? He's, after 2.5 years, got an appointment to get a HUD apartment, and now that's for tomorrow morning.
Yeah, and you know what? Pretrial just showed me a warrant for him. That was the
warrant.
right?
I don't have no
Fraud?
warrant. I don't have no warrant.
Pretrial release has a warrant for uttering a forged instrument.
Uttering a forged instrument?
Yeah, but I go back to court August 24th.
Okay,
The
Judge
basis-
Berrigan revoked his release this morning.
The basis of the violation is the MO, I think. Is that correct? So they're violating him on the MO.
The basis of the violation is the misdemeanor ordinance.
Thank you, Judge.
Okay.
That's
Lamont
it,
Hall.
Mr. Brown. They're gonna keep you over till tomorrow. So you're
I'm
gonna miss your
absolutely
appointment.
going to call plantation, tell them to be here tomorrow.
Okay, all right, thank you.
North Broward, Your Honor, for Lamont. North Broward.
North Broward?
Yep, there you go. Hello, Your Honor.
All right, this is a
Come on up, Mr.
30-day
Dunlap.
hearing, motion for ROR.
I mean,
State
Mr.
law
Thomas,
charges.
have a seat right there. Huh?
No, Your Honor. And today's the 33rd day. He is entitled to release today.
All right, Mr. Hall, today's your lucky day. You're going to be released on your own recognizance. The state has failed to show good cause as to why they've not filed charges. You've been in custody now for 34 days. Is this the only case holding you in jail?
Yes, ma'am.
All right, you should be
Yes,
released
ma'am.
shortly. This does not mean that your case is dismissed. It just means that the state's not made a filing decision. So if the
Yes,
state
ma'am.
does file charges against you, you're going to need to come to court to answer those charges. Do you understand?
Yes, ma'am.
All right, good luck.
Yes, ma'am. Thank you very much, ma'am.
All right. John Region.
Conti, Your Honor.
All right, good afternoon, Mr. Region. We're here for a 30-day rule violation defense motion for ROR as a state file charge.
Your Honor, from what I can see in my system, it looks like we're going to be declining charges, so I have no objection to his release at this time.
All right, you hear that?
Yes, sir. Yes, ma'am.
All right,
Your Honor, what I would, if I could ask, I would ask the court, because at this point it hasn't officially been declined, so if you just advise him the no contact order is still in place, he can contact his public defender to confirm if the charges have been declined or not.
Okay, but your office is showing an intent to decline.
Yeah, so I have no objection to his release. I just, in an abundance of caution at this point.
All right, sir. It's the state attorney's intent to decline prosecution on each of these two charges, so I'm going to release you on your own recognizance for each of them.
Yes, ma'am.
But that no contact order is still out there until the state's no information hits the court file. So
Yes,
when you
ma'am.
get released from custody, do not have any contact until your case is officially declined.
Yes,
You
ma'am.
understand?
Yes, ma'am.
Okay. All right. Best of luck to you, sir.
Thank you, Judge.
All right, thank you.
Kenneth Baker.
Conti, ma'am. I'm sorry, you can go back.
Okay, good afternoon, sir.
Afternoon.
We're here on a disorderly intoxication and resisting without violence. He's been in custody for how many days? 6 days. This is a second look to see if he can resolve
Yes,
it?
these, I think they're all second ones, so here I am now.
Okay, state,
I'm just checking to see what the allegations in the report were, Your Honor.
When you guys come out? No, we won't.
okay, okay. Okay, all right. I was wondering why they're both.
Your Honor, state would make an offer of adjudication time served. If you want, and I guess we get to that point, I can give you a proffer.
Okay. All right, Mr. Baker, the state's offer is an adjudication 6 days in the Broward County Jail, credit for 6 days served. Do you want to resolve your case here today?
Yes.
All right. Is this the only case holding you in custody?
Yes.
Your Honor.
Raise your right hand. Raise your right hand. Swear from, tell the truth, the whole truth, nothing but the truth.
I do, Your Honor.
All right, place your hand down. Please state your name for the record.
Kenneth Lynn Baker, Jr.
All right, do you want to plead no contest to disorderly intoxication and resisting without violence?
That's correct, Your Honor.
All right, the state, give me a factual basis.
Yes, Your Honor. On June 4th of this year at 3631 West Commercial Boulevard in, it looks like North Lauderdale, Your Honor, the deputy was called to the scene with regard to an intoxicated adult male. Deputy got to the scene, observed the defendant in possession of 2 open containers of alcoholic beverage. He was drinking the alcoholic beverage in the officers and the deputy's presence. Defendant was acting belligerent, threatening the property manager and the deputy. He was continuing to cause a disturbance, yelling obscenities, threats of violence. The deputy went to place him under arrest. Defendant refused to place his hands behind his back, stated he was not going to jail, and took a fighting stance. Deputy ended up using his taser on the defendant.
All right, fine. There's a factual basis for purposes of the plea. All right, sir, I'm going to adjudicate you guilty, sent you to 6 days in the Broward County jail, credit for time served, court costs, mandatory fees. You should be released shortly, sir.
Okay.
Tracy Jackson.
North Broward, Your Honor.
Tracy Jackson, okay.
Hello, how are you?
All right, been in custody 6 days. The state have an officer resolve this.
Just one moment, Your Honor. Your Honor, the state's offer at this time would be and adjudication time served. Actually, you know what? I'm sorry, Your Honor. Your Honor, the problem is this involved a fare to taxi, not paying a fare. It looks like there's restitution issues. I'm really not prepared to make an offer involving restitution without probation. I really can't do probation out of this division. If you want to take that in consideration, though, for bond, Your Honor, I can tell you she does have an assault and aggravated battery prior in her past. I don't see any theft priors in her past.
It's for bond right now.
Deputy Williams? I can't afford it. I don't have no money.
Judge, the court can always reserve as to restitution. The court can always reserve as to the restitution amount. It's a cap.
And the state's position is, Your Honor, really without probation in place to enforce the restitution, it's...
How much is the restitution?
One moment. It's hard to read. It looks like it might be $12.50. I can't be 100% sure.
$12.50.
Yes, Your Honor.
All right. And if you want to resolve your case here today, I'm going to adjudicate you guilty, sentence you to 6 days in the Broward County Jail, credit for 6 days served. Is that how you want to resolve your case?
Yes, ma'am.
All right.
Yes,
Raise your
ma'am.
right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth.
Yes, ma'am.
All right, place your hand down. Please state your name for the record.
Tracy Lakim Jackson.
Okay, you can place your hand down. All right. I understand that there was it was a theft of cab fare in the amount of $12.50. So I do find there is a sufficient factual basis.
The only other issue, and if the court could clarify when sentencing her, because I see if she has an address, because I assume if the court's going to order restitution in the amount of $12.50, I can prepare an order, but the clerk's office is going to have to mail it to her.
Okay. All right, ma'am, do you have an address?
Yes.
What's your address?
Yes, I do. 735 Northwest 11th Ave in Fort Lauderdale, Florida, 33311.
Okay.
33341. All right.
No, 33311.
Sorry.
33311.
Okay.
Trees.
All right, ma'am, if you understand, if you get, was it 3 petty thefts, it becomes a felony? All right. You get 3 petty thefts, the state could opt to upfile these charges against you. If you keep picking up these theft-related charges, the state could enhance the penalty up to a felony charge. You still want to go through with this plea, knowing that?
Yes.
All right.
Yes, ma'am.
And do you wish to plead guilty or no contest?
No contest.
All right. You want to give up your right to a jury trial?
Yes, ma'am.
Give up your right to confront and cross-examine witnesses?
Yes, ma'am.
You give up the right to have the state prove all the elements of this charge against you beyond a reasonable doubt?
Yes, ma'am.
You give up the right to an appeal?
Yes, ma'am.
All right. How old are you?
I'm 27.
How far did you go in school?
Some college.
Read and write the English language?
Yes, ma'am.
Under the influence of any drugs or alcohol at this time that would affect your ability to understand what's going on?
No, ma'am. Only
Do you
juice.
suffer from a mental illness?
Yes.
All right, does that mental illness interfere with your ability to understand what's happening here today?
No.
All right, and the maximum penalty for this charge is up to 60 days in jail. You understand that?
Yes.
All right, I find that your plea is freely, voluntarily, intelligently entered with the advice of, she has a PD on this?
No.
All right, I will appoint the public defender's office for today. She does have counsel representing her, and her plea is freely, voluntarily, intelligently entered. I'm going to adjudicate you guilty, sentence you to 6 days in jail, order you to pay restitution in the amount of $12.50 to, what's the name of the cab company?
It's, Your Honor, I just have the name of the driver, Esperando Alcius.
All right, you're going to pay money to the cab driver.
Okay.
You have 30 days to appeal the legality of the sentence. Best of luck to you.
So I'm out? I'm out?
You're out if this is the only thing holding you.
Okay, thank you.
All right, good luck.
Judge, could you call Paul Thomas next?
Oh, Your Honor, so...
Judge, Felipe Nistal is a medical reset.
All right.
Well, Your Honor, if I may,
Yeah.
frankly speaking, I can tell you right now, the state is not going to have any offer and is going to ask that he go to his division.
All right, we're going to send this to a regular division.
Thank you,
The
Judge.
state doesn't have an offer.
Can we call Paul Thomas next? He's the last one over here at the main.
Okay. Paul Thomas.
President, the main judge, he is anxious to resolve the case if the court is so inclined.
State have an offer to resolve Paul Thomas.
One moment, Your Honor. Just need to see if the location that the trespass occurred at.
Just while he's looking, did you have any others from this morning for the MO cases? We're still showing 2.
I don't have any more now. Not that I think we handled them all.
May have resolved.
There were 2 medical resets this morning, Mr. Atria.
That may be the ones, okay.
Thank you, Judge.
Okay. All right, thank you.
Okay. Your Honor, he does have a record. However, the state's offer today would be adjudication time served.
All right, does he want to resolve
work
that?
for you?
Adjudication time served?
Adjudication time served, you go home.
Yeah.
All right, sir, you want to raise your right hand? Other
Right
right.
hand.
Other right.
Kind of hurt.
Oh, I'm sorry. Okay. Are you swear firm to the whole truth, nothing but the truth?
Yes, ma'am.
Yeah?
Yes, ma'am.
All right, you can place your hand down. Please state your name for the record.
Put your hand down.
Paul Anthony Thomas.
Okay. And you want to
You can
plead
put your
no
hand down
contest to
there.
this charge of trespassing? Yes?
He said yes, ma'am.
Yes,
Okay.
ma'am.
Is there a factual basis?
Yeah, Your Honor.
Sorry, you don't understand. I'm in pain.
The allegations are that on June 6th of this year at 1851 North University Drive in Plantation, Officer Plantation PD was called to an Arby's where Mr. Thomas was, who had recently been trespass warned, was in the parking lot. The officer talked to the manager and confirmed that Mr. Thomas had been issued a trespass warning at this location on March 22nd, 2015, and lists the Plantation PD case number.
Okay, well, there's a factual basis for purposes of the plea. All right, sir, I'm going to adjudicate you guilty, sentence you to 4 days in the Broward County Jail, credit for 4 days served. Court costs
Thank you, Judge.
fees.
Thank you, Judge.
Thank you, Judge.
That's it for the main?
That's it for the main.
All right.
We'll see you next week. I'm out. This is my
Over now.
vacation starts tomorrow.
Okay.
I'll be out for the rest of the week, Judge.
Okay, all right.
Teresa's gonna miss you.
Yeah. You put
Nah, I don't
Mr.
think
Miller,
so.
tell him no return to that location.
You hear that?
Thank you,
Paul
Judge.
Thomas.
Mr. Thomas? Can't go back to Arby's. Roger that.
Your Honor, Paul Ryan has one more, Kathy Akins.
I guess that's bad.
Want to call your case?
Antoinette Evans.
Okay.
Your Honor, thank you for putting this on the docket. I appreciate it. It's kind of an odd situation. Miss Evans, on May 29th, was arrested for a window tint violation in addition to driving while license suspended without knowledge. She was immediately ROR'd when she came to magistrates on the 29th, but they kept her in custody and are still holding her on 948.06 hold. Miss Evans is on probation. It's a grand theft third degree out of Palm Beach County. There is no warrant pending. It's a 948.06 hold on traffic tickets, and we are begging the court, especially since she retained local counsel, to ROR her on those charges. If and when Palm Beach County does decide, which, as Your Honor well knows, the judge might get the warrant, come across her desk, and not sign it. If and when charges do get filed, she has already retained local counsel, not only for this issue, but for the Palm Beach issue. We're begging the court to release her ROR so she can go on about her business.
The problem is that I don't have jurisdiction to touch another case from out of county.
Well, actually, it's not. That's the problem. Palm Beach County hasn't done anything. Palm Beach County hasn't violated her. There is no warrant pending out of Palm Beach County. It is Broward County. When the officer arrested her, the officer ran her name through NCIC and came back that she was on a felony probation out of Broward County. And based on that information alone, when they booked her into the main jail, they put a 948.06 hold. What the law says, it's the Widman Act, passed in 2011. And what that law says, previously only a probation officer could have filed a warrant to hold someone no bond or to get them back in front of the judge, the sentencing judge. Now what it allows is if there's probable cause for any officer of the state that the individual was on probation, they can hold them until they're brought back to the sentencing judge in short order. They're supposed to be brought back to the sentencing judge as soon as possible. The problem is Palm Beach County ain't going to be picking her up because Palm Beach County has not signed any warrant. It is Broward County that is holding her simply based on the 948.06 hold the officer placed on her when they booked her at the main jail. So we're not asking the court to go, and I would agree, if a warrant had been issued out of Palm Beach County and the sentencing judge had put a bond amount, or no bond for that matter, in the warrant, I wouldn't be here. We wouldn't be asking the court to do anything because we'd be waiting for Palm Beach County to pick up Miss Evans. But as it stands...
Has the Palm Beach County judge that placed her on probation, has that judge been notified that she picked up a driving while license suspended charge here in Broward?
When I spoke to Terrence Lynch, I tried to get BSO involved right away because my feeling was that Miss Evans is being held illegally. When I talked to Terrence Lynch, he assured me that confinement status, once Miss Evans was brought to the Broward County Jail, notified probation, the Department of Corrections, that she has been in custody. And I verified before I left my office to come here to magistrates, I checked the computer system. As an officer of the court, I can verify and stand before you and say that no warrant has been filed. If a warrant is filed, Judge, I have already been retained to represent that eventual case. She lives in...
Talking about the judge that placed her on probation.
Yes.
That judge, has that judge been notified that she's being held on a probation hold without a warrant that judge signed?
That I don't know. What Mr. Lynch had...
But which judge is it?
I don't have that information in front of me right this second.
Some judges regard driving while license suspended charges to be serious and
it's
to
without
issue
knowledge.
no bond holds on their warrants. So
it's a without knowledge, Judge. It's
I know, but there are some judges who would regard that to be serious and would sign no bond warrants for a traffic violation.
Yes. Yep.
I need to know who that judge is, and if you want me to call that judge right now, get that judge know. We've got somebody that's being held now for how many days? 9 days?
I'm not certain
it's
when she
almost
Since
almost
May 29th?
May 29th, Judge.
And this is your probation in Palm Beach County, and there's no physical warrant, but it's a 948 hold, and she's been in jail now for 9 days. Do you have a problem with me releasing her? Find out who the judge is that put her on probation. If that judge doesn't have a problem, with me signing an order, I'll do it, but you need to find out who that judge is.
Yes, Your Honor.
Like I said, some judges find it to be serious, that people get arrested for traffic-related charges. So I'm not the judge that placed her on probation in Palm Beach, so I'm not going to get involved with that unless I have permission from the judge in Palm Beach.
Yes, Your Honor.
Okay? All right, and you want me to set this back on the docket tomorrow? I will.
Please.
Okay, afternoon or morning?
If you set it on the morning docket, do I have time to? Can I call it at a turn or?
Any time in the morning.
And I can just come up and.
Yeah, that's
okay.
fine. That's fine. Just let me know the name of the judge. You can put a call into
Absolutely.
their office.
I'm gonna get all that squared away today.
All right, sounds good. And give you name, address, phone number of that judge, and if we need to call that judge, I will. I'll do it. And if
Yes,
they
Your
don't
Honor.
have a problem, that's the judge who placed her on probation. They don't have a problem with me RORing around that. I don't mind doing it.
Yes, Your Honor.
Okay?
Okay.
All right, thank you.
Thank you. I'll see you tomorrow.
All right, thank you. All right, Kathy Akins.
Paul Ryan, Your Honor.
Hey, Lewis, I'm trying to call you. Something's on your line.
All right, this defendant's been in jail now for 4 days, and the state have an offer for her to resolve it.
One moment, just checking the allegations, Your Honor. Here it is. Your Honor, state's offer be adjudication time served.
All right, ma'am, do you want to resolve your case today?
Yes.
All right, the state's offer is an adjudication, 4 days in the Broward County Jail, credit for 4 days served. Is that how you want to resolve it?
Yes.
All right, you want to raise your right hand? Swear firm, tell the truth, the whole truth, nothing but the truth.
Yes.
All right, you place your hand down. State your name for the record.
Kathy Ann Akins.
All right, do you want to plead no contest to this charge?
Yes, ma'am.
All right, is there a factual basis?
Your Honor, on June 6th of this year, 831 Northwest 9th Avenue in Fort Lauderdale, Fort Lauderdale police officer was patrolling the area, observed Miss Akins panhandling at a Sunoco gas station. There are no trespass signs posted with an affidavit on file. The officer trespass warned Ms. Akins. She refused to leave the property. She was placed under arrest for trespass.
Okay, fine, there's a factual basis. All right, ma'am, you want to plead no contest, correct?
Yes.
All right, I'm going to adjudicate you guilty, sentence you to 4 days in the Broward County Jail, credit for 4 days served, no return to that gas station.
All right.
And court cost mandatory fees. Best of luck to you. Michael Finkelstein.
Conti, Your Honor.
All right, state have an offer to resolve this.
I'm just checking his record real quick. Just to let you know, whatever you want to do, I'll make an offer, but I can see he's had 2 cases in Broward in 09. Both went through Judge Lerner Wren's division. So I don't know if you want to inquire of him or before I make an offer. It's up to you.
Sir, the state is prepared to make an offer to resolve your case today. Do you understand what a plea is?
Of course.
Do you know what no contest means?
Yes, I do.
Okay. What's your understanding of what it means?
It means if I press no contest, it means I'm not guilty.
No, what it means, sir, is that you're not admitting or denying the allegations, but you're pleading. It's a plea of convenience. You're pleading because you want to get it over with. You're not admitting guilt. Do you understand that?
That's correct.
Okay. What's your understanding of what you're charged with?
Petty theft.
Okay. What does that mean?
It means I took something that wasn't mine.
Okay. And how's petty theft different from a grand theft?
It's a much smaller amount.
Okay.
in mental health court with Judge Wren, or?
No,
He
he was
He's not
previously
currently.
there.
That's why I wanted to just bring it to council's attention before entering the plea.
My only concern is that he when I asked him what no contest meant, he meant not guilty. He says he wasn't guilty, but I just want to make sure because I don't want him sitting in jail.
All right, what's the bond amount on this?
With the court ROR. No. So, sir, remember when I asked you what no contest means?
It means I'm not pleading guilty or not guilty, just no contest.
All right, what's his bond currently?
It's $100, and I just want to see one other thing.
Do you understand? The state's role? What's a prosecutor's job?
Just to follow protocol.
To what? I'm sorry.
To follow protocol,
Your Honor.
What protocol?
Hopefully I can be released.
He had a theft last year that ended up getting another case that ended up getting transferred to Judge Leonard Wren. He just pled that out in mid-March. I mean, I understand he may end up just going there and pleading this out, but it's up to you. I'm not trying to push you. I just don't know.
Judge, it's just some of his answers. I mean, when I asked him what the state attorney's role was, he says it was to follow What's the defense attorney do? Well, what does a public defender do?
Defends the defendant.
Okay. What is a judge's job?
Hopefully, to follow the protocol.
And I'm not saying that I necessarily think he's incompetent to take a plea. I just think there may be other issues that Judge Leonard Wren might be able to help him with.
He's got a $100. This is holding him on
I've got a $100 bond, but Your Honor, it's Tuesday. I'm pretty sure, and I can check, but I think she does a docket on Thursday.
She does.
If you transfer now, I think in order that he be put on her Thursday docket.
Okay.
Can we put the matter in front of Judge Leonard Wren on Thursday?
That's what I want.
All right, you're going to go in front of Judge Wren on Thursday, okay?
Remind me, we'll check with
What time,
tomorrow
ma'am?
to make sure.
Probably 9 a.m.
All right, right now I'm going back to my cell.
Yes, you can.
All right, thank you.
All right.
Peter Gale. Just remind me, write down the case number. We'll check tomorrow morning.
North Broward, Your Honor.
Peter Gale, okay. He's been in jail
Yes,
now
Joe,
for 4 days. State offered to resolve it.
Just checking the allegations right now.
I don't have no keys or nothing.
Yeah.
Okay.
Hopefully Thursday.
Yeah, we're gonna check with Marge tomorrow. She'll check to make sure that it made it onto that docket. Okay, Your Honor, I reviewed his probable cause affidavit. The state's offered being adjudication time served.
All right, sir, you want to resolve this case today? The state's offered you time served.
Yes, ma'am. Okay, that's all right.
All right,
Thank
you. Want to raise your right hand?
I guess.
Wanna
Yes,
raise your right
ma'am.
hand? You swear firm
Yes,
testimony,
okay.
the whole truth, nothing but the truth.
Yes, that's the truth.
All right, place your hand down. State
Nothing
your
but
name
the
for the
truth.
record. State your name for the record. State your name.
Peter Gale.
Okay, you want to plead no contest to this charge?
Okay.
Do you want to plead no contest, yes or no?
Yes.
Okay. Is there factual basis?
Your Honor, on June 6th at 5562 West Oakland Park Boulevard, police officer from the Lauderhill Police Department received a call from a representative of business that they, Mr. Gale was causing a scene, tried to have him removed. Mr. Gale refused to leave. The officer issued a trespass warning at approximately 8 p.m. Shortly thereafter, Mr. Gale returned to the location, and the officer was dispatched back to the location and made contact at the location with Mr. Gale and took him into custody at that time.
All right, fine, there's a factual basis. All right, sir, I'm going to adjudicate you guilty, sentence you to 4 days in the Broward County Jail, credit for 4 days served, court costs, mandatory fees. You're done.
Bye, Judge.
All right, David Vargas. And also no return. David Vargas. Which jail is he in?
I don't know, I'll check. Oh, really? I know. Someone was
Yeah, it's dark there.
Yeah, I guess the only place left could be Conti.
David Vargas.
No, he's at Maine, I'm showing.
David Vargas. No.
He's definitely not there.
Maybe
If you want to no, I'm
showing he's in jail?
Yes. I'm showing that he's not posted. I don't have any objection if you want to reset for tomorrow.
Okay. AM or PM? PM, right?
Sure.
Yes, I'll be out here.
The
last two guys are in Conti.
Lewis McCrae.
Good evening, Your Honor. I'm present.
Where are you?
Conti.
Lewis McCrae. Okay, good afternoon, sir. You've been in jail now for 4 days.
Judge, I do know Mr. McCrae. I used to previously represent him. He's a pleasure to deal with. I mean, would the court just consider resolving this case? Lewis.
Yes,
It's your former attorney, Fossil. Do you want to resolve your case today?
If I would I would strongly desire to.
Okay.
Just checking.
Have an offer.
I will, Your Honor. I'm just checking one thing. Okay. Your Honor, because Mr. McCrae hasn't been arrested in Broward since last year. Hold on one moment. Fossil. Your Honor, can I confer with defense counsel for just one moment, please? Thank you.
Screaming.
With authority.
I'll resolve it. All right. All right, Judge.
Time served?
State's offer to be time served.
All right, Mr. McCrae, want to raise your right hand?
Yes, ma'am.
Swear firm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, place your hand down. State your name for the record.
Lewis William McCrae.
All right, you want to plead no contest to this trespassing charge?
I do, Your Honor.
All right, is there a factual basis?
Yes, Your Honor. On June 6th of this year at 6921 West Broward Boulevard in Plantation, Mr. McCrae was observed by a store manager of the Publix on the property. He had been previously trespass warned on May 23rd of this year. Plantation police was called to the scene. Officer observed Mr. McCrae on the property, confirmed that he had previously been trespass warned under Plantation Police Department case number. He was placed under arrest for trespassing. We just also, and I know you will, Your Honor, just order him obviously not to return to this location, please.
Okay. All right, I found there's a factual basis. I'm going to adjudicate you guilty, sentence you to 4 days in the Broward County Jail, credit for 4 days served, and no return to that location. Court costs mandatory fees. Best of luck to you, sir.
I'm grateful, Your Honor. Have a most enjoyable day.
Okay, you too. Okay. Ismael Brutus?
Conti.
Present.
All right, this is a battery.
Yes, Your Honor. Obviously, the state has no offer.
Why is it on the second lookout?
It's pursuant to administrative order. All misdemeanors pretty much are eligible for second look review, so it just gets put on. It's very rare when anything. They're never resolved, and it's very rare when anything gets modified on a battery case that comes through in a second look. Your Honor, I can tell you, the allegation is that that Mr. Brutus struck the alleged victim 3 times in the right eye with a closed fist, causing the victim to fall to the ground. Once on the ground, the defendant continued to strike the victim with his hands and feet until separated by bystanders. Strikes caused visible swelling and bruising to the victim's right eye and the surrounding area. Then the defendant fled the scene. Surveillance footage from inside the business and a witness on scene corroborated the victim's account. A show-up was conducted, and the victim positively identified the defendant.
I'm not inclined to resolve this today. Why don't we just transfer it to a regular division?
That's all I'd be asking for, Your Honor.
All right, so your case is going to be transferred to a regular division. We do Jacob Mathis?
That was the municipal ordinance I think you resolved earlier.
Still for the self-defense. Your Honor, can I speak?
No, sir, you're going to have to resolve your case in a regular misdemeanor division. It's not going to be pending in front of magistrate court any longer. All right, is that everything? Yeah. What is it? Oh, photo order. Okay.